Hello, everyone. My name is Mary Oldham, and I'm the funding coordinator for Bellomo and Associates. We at Bellomo and Associates are happy that you've decided to move forward with your protecting your assets and with the choice of estate planning. As Attorney Bellomo has mentioned throughout his workshops, it is important that you put your assets in the trust or designated after death in the trust. The funding part of it comes in after you sign your documents and we receive copies of your asset statements or some type of sheet stating what assets you want to put into the wagon or the trust. What I've done is I've created a couple of documents for you to help you with this. One is an asset table, which is a combination of all the assets you provided me, and I put them in a detailed order. For example, there are 5 different asset categories, such as cash, non-qualified investments, qualified investments, which are your IRAs, your 401ks, your pension, and then your life insurance, and then obviously your properties like your home or rental property or investment property, whichever you have. And then I've also created a funding note sheet just to help you as a little cheat sheet to help you with the funding when you're trying to do it yourself. Okay, so I'm going to go over both of these right now. The first one that I want to show you is the actual asset table itself. So I'm going to open that up for you. Okay, so again, this is a combination of all your assets that you provided me. This is a mock asset table. This person doesn't exist. None of these assets exist. I just kind of made it up just to kind of give you an example of what one would look like. Okay. So I have created all these different columns. And the first column, which is going to be for every single type of asset, is your company or financial institution where you hold that asset. So your cash assets are typically your checking, your savings, your money market or CDs. Okay, and those are usually held at like a bank or a credit union, some type of financial institution. So that's listed here on this column. Then you got your type of an account, the last 4 account number, digits of the account number, and then the asset owner. It could be individual or joint. In this case, I just made it individual, but it could be a joint account as well. And then a rough estimate of what your balance is at this particular time. Obviously, these amounts can change as you use the funds. Now, the second half of the asset table kind of lays out what designations we're going to provide. So it's a conversation you will probably have with your one-on-one with your attorney. As you know, you are entitled to have a revocable trust and a irrevocable trust. Now, just to give you an example, typically a checking account that you use on a regular basis where the money flows in and flows out and you use it for your care or your daily expenses, typically we put that in a revocable trust because as they've educated you on this, a revocable trust, you can use the assets just like you can if it was in your name alone or your joint names, okay? So a lot of times your accounts where you're using them on a regular basis, you probably want those in the revocable trust, all right? And here you can see I have labeled that for these two, this checking and the savings account. That's the owner that we would change it to. The next column is your TOD, transfer on death or beneficiary. Now this one typically, we won't need it all the time in the cash asset category because if you change the owner to the trust in the banking world, that's sufficient enough to have it play out for your beneficiary designations according to what you put in your trust at the time of your death. Okay, so that's going to take care of the beneficiary as well. Now, for example, if you have an asset that you place in as the beneficiary, the trust is the beneficiary, then in that case, we're not changing the title of the asset, but if one or both individuals on the account pass away, then it funnels through the trust. So it doesn't have to be probated. Okay, so that's kind of important too. If you're not going to place the asset in the name of the trust, then maybe you want the trust as the beneficiary. The next column is notes. These are notes that, are just helpful for understanding anything that we need to know about that particular asset. Now, I'll use this one as an example. Sometimes my clients say, you know what, I don't want that in the trust for whatever reason. So I kind of notate that. And then I put over in the status column, no changes, because we're not really going to do anything with this. We're not going to fund it. We're not going to put the beneficiary designation. We're not going to change anything on it. And then up here, I put funded. This would be, after that's actually happened. Okay, so then I just put the status up there as to where we are in the process of completing the funding. Sometimes you'll see down here I have pending. That just means that we've started it or you've started it, but it just hasn't been completed yet. All right, so if we go down to our investment assets, same thing, you got your company name, you got your account type. These are typically non-qualified investments. So they can be anywhere from stocks, bonds, mutual funds, those type of vehicles that they could be placed in. And then you got your account number, your asset owner, the value roughly. And then again, here is the allocations that you've decided with your attorney, what best fits your needs. Okay, if it's going to be in the revocable or the irrevocable trust. Now, again, sometimes the irrevocable is for your larger assets, the ones that you don't access on a regular basis, and you want that protected from Medicaid creditors or predators during your lifetime. And obviously there is that 5-year look back, so that would be protected after the 5 years. And then again, obviously we want our trust to be our beneficiary for the after death protection. And here in the notes, you'll notice that I've made notations for financial advisors and how to contact them. This is really important because, as I'll discuss later in this video, working with a financial advisor to make these changes is going to be key for you if you have one. It's going to make things a lot smoother and easier and quicker. And I'll explain why in a few minutes, but just that's kind of where I put that information. And then again, here, your status. This could be a situation where you've worked with your financial advisor, he's gotten it started with the documents that I've provided to you to help him fund it. And it's just not, he's just started it and it's not completed yet. So we know that it's in the process. He's maybe sent it to the companies, but we just haven't gotten verification back yet from him that it is completed. So I kind of just place a pending status on that until it's completed. And then once it is completed, I'll obviously put funded there. Retirement accounts. These are typically your IRA, traditional IRAs, your Roth, your 401k, pensions, etc. Again, you got your company name, your asset type or title, and account number, who owns that asset at this particular time, and the value. Now, with qualified assets, which are your IRAs, we're not allowed to change the title of that asset for tax purposes. There could be a tax consequence on that. So unfortunately, you can never really protect the IRA asset while you're alive. It can only be protected after death because we cannot change the title. It has to stay in the owner of that particular IRA itself. However, we can place a beneficiary as the trust. And here as the primary beneficiary, we have labeled the spouse-only retirement trust for the benefit of the spouse of the owner of that particular IRA under the name of the trust. The reason for this is because back in 2021, there was the Secure Act passed, and so we have to kind of have that spouse-only retirement trust verbiage as the primary beneficiary for your IRAs. Then under the contingent tab, I have placed 100% to the spouse of that IRA owner. Now you may ask, why do we do that and not our kids or whoever else you've named in your trust, okay, if both of you are passed. The reason for this, and I'm going to answer this now because I know this question will come up. The reason for that is so that when the IRA owner passes, the spouse of that IRA owner can decide at that time if he or she wants that asset to go into the spouse-only retirement trust for his or her protection from predators, creditors, or Medicaid if they happen to go into a nursing home. Or they can say, you know what, nope, I want that money outright. I need it. Need to use it for something right away. I want to take that cash. So by naming the spouse outright, they can actually disclaim at the time of the owner's death how they want it to go, either to themselves directly or into the trust protected for them. Now, in the case where, let's say, potentially the spouse precedes the owner in death, because we have labeled the primary beneficiary as the trust, it would still go to your heirs or your children based on how you did your trust, because we labeled the trust as the primary beneficiary. Okay, so you don't have to worry about that. It's still going to go through the trust. And then your notes, again, is your financial advisor if you have one, especially if you have assets that you manage through a broker. You really kind of want to have that information handy for yourself. And if you have a 401k, again, later in this video, I'll explain how we're going to make changes to that. It's probably going to have to be through their website. And then status. You know, if the beneficiary changes are complete and they're confirmed, which you definitely want to get confirmations from all of these different financial institutions, companies, financial advisors. You always want to get confirmation as to when they are actually completed, and all the verbiage is retitled or the beneficiaries are completed, so that you know that it's done. It's not somehow got lost or just never finished. You just want to make sure all that's done so that it is actually, your trust is either the title of the asset owner or the beneficiary. And again, if there hasn't been anything started on it yet, you usually just leave the status as need allocations. That means nothing's really been started on that. And then going down to your life insurance. Typically life insurance, you know, there's a lot of the same companies that I see all the time, Prudential, Transamerica, just there's a lot of similar companies that everybody uses. But then there's the policy number. The policy type is very important. So you see here, I have labeled term and whole life. And as you probably know, term insurance just has a death value. So in that case, we would only list the beneficiary on that policy because there is no cash value. So we're going to protect that after death. So there would be the trust as the beneficiary. And then if there is cash value, we recommend that you put the trust as the owner and the trust as the beneficiary as well, so that that cash value has protection while you're alive. Obviously after the 5-year look back, but it does have protection while you're alive. And then you also have the protection after death with the beneficiary designation. Again, can't stress enough that having an agent or somebody to help you with this document is very helpful. So if you have an agent, I like to list them here as well as their contact information. And then again, our pending status or completed status here under the status column. The next one is your real estate. Now, this would be probably your primary residence, the homestead, if it's a homestead, and then the current owners, the value, and then obviously the name of the trust that you so choose to put as the owner of that property. Now, the law firm will take care of all this. We will file the deed with the county. Okay, you'll get a copy of that when it's completed. That is included in the cost. Okay. However, if you have other properties, we can take care of those as well. But if it's in Pennsylvania, there would be an additional fee for that filing. And I believe it's $250. If you have real estate that's outside of the state, like in Maryland or Delaware or anywhere in the United States, you have property or, you know, a vacation home or rental property, something to that nature, we can file that for you with the help of an out-of-state attorney that we can access. However, we will get billed from them and we would transfer that cost onto the grantors of the trust, just to let you know how that all works. And then also on this asset table, just for your review, I kind of made a little note as to what a revocable trust allows you to do and an irrevocable trust, and how we've kind of labeled those so you understand the difference between the two. Usually the attorneys will put the name of revocable in the title of the trust so that you know it's revocable. And then the other one, we usually just say the family trust, and that's the irrevocable trust. Okay, now I want to go ahead and kind of show you the notes that I've come up with to help you with this funding. I've created this myself just based on what I've done with funding. So again, kind of to repeat myself, back on the asset table, you see the different categories here of assets. So you have your cash assets, your non-qualified brokerage/investment accounts, your qualified plans, which are your IRAs, your 401ks, your pensions, okay, or your broker and managed IRAs. Sometimes you have IRAs at banks as well. You might have an IRA CD, anything that's labeled as an IRA. And then your insurance policies, your term and your whole life. So starting up here with your cash assets. Now you're checking your savings, your money market, your certificate of deposit. Those, like I said, again, are usually at a bank, some financial institution, credit union. Those usually require that you have to come into the branch to handle that because you have to sign a new signature card. So you have to make an appointment with your financial institution, letting them know that you're either going to change the title of the asset or open a new asset in the name of the trust and or beneficiary information. And I will provide you with instructions and a certificate of trust. And usually that will be put through the portal or email, whichever way you prefer. I'm happy to take care of that. I can even mail them to you, whatever way you prefer to receive those instructions. I'm more than happy to accommodate that. But again, with your cash assets, I did work at a bank for 30 years. I know that you're going to need to actually go in there because they're going to change it. They're going to need a new signature card. And, you know, they get busy. So I recommend an appointment so that you don't have to wait. You can get right in there and get your stuff done. And then again, have them give you some type of confirmation that it's been completed. Your next non-qualified brokerage investment accounts. Like again, those are usually your stock, bonds, mutual funds that you have investments in. And if you can work with a financial advisor to make those changes, it's going to be very beneficial because he or she can usually get those documents done for you and then just have you sign them and you don't have to deal with any of that. And then I would obviously, you would need to give them the certificate of trust that I will provide to you, as well as instructions that I will provide to you for each investment that you have that's on your table. So you will have a set of instructions for every individual investment that you have. Okay, account number, whatever it is. And then you'd have to provide, if it's one advisor, you can probably just provide him with one certificate of trust and he'll just make his own copies if he has to send it to other companies. But I will definitely give you instructions for each one. So it'll make it easier for you to provide to him or her. If for some reason you don't have a financial advisor, which sometimes is the case, that's fine. You just have to gather the forms that you would need from those particular companies as to make either an ownership change or a beneficiary change, or both. Sometimes those forms have both on one form. Sometimes they're separate forms. You just have to look under that, maybe call the company sometimes, or you can look under the internet and try to find those forms. If it's a company that I've dealt with before, I can probably help you with those forms, or let you know where I can maybe send you a copy of the forms. The only thing is I don't know if I have the most updated version, and they're kind of picky about that. So sometimes it's better just to talk to the company themselves and have them email you the form. And it's a lot easier. Or sometimes, like I said, you might have a user ID and password where you can sign right into that company and make all those changes in an appropriate tab that applies to what you're trying to do. Again, ownership or beneficiary, there's probably a tab that specifies ownership change, beneficiary change. Okay. That's going to be probably the quickest way to do it as well. If you don't have a financial advisor, just to let you know that. So if you don't have a user ID and password, but you can get one, maybe it's to your advantage to probably do that. Just from what I've seen from accessing these websites. And then your IRA, your qualified plans, which are your pensions, again, your 401ks, or maybe your broker managed IRAs. If you have an advisor to help you with these changes, that's again key, because it's going to make it a lot easier for you, a lot quicker. They're used to seeing these forms, they fill them out in no time at all. Obviously, if it's a 401k, you're probably going to have to access your employer website, your HR website, to make those changes. Usually it's not too difficult. You know, they make it pretty easy to maneuver around in there, but you're probably going to have to access or get with your employer HR to find out where you get these forms from. And then again, with your IRAs, just remember, we cannot make title changes. We can only do beneficiary changes. So there would never be a title change. It would only be a beneficiary change into the spouse only retirement trust. And then obviously the spouse is contingent outright. Now, if you don't have a spouse, for example, then you could name it as the retirement trust would be labeled as the primary, and then the contingent would be the actual separate shared trust for the child or the heir that's going to inherit it. So you'd still want to label the trust as the primary, and then the contingent would be the separate shared trust that is mentioned in your Article 5 of your trust, as to who that is and how you title that. I would give you instructions on that for that particular titling of the beneficiary. If that is the case, I'm going to give you instructions for all of that. So that should not make it too difficult for you. I would look at your individual trust when I do these instructions. So I would make sure that I have the correct titling for that beneficiary change with the correct individual that you have named. With life insurance, same thing. You can have term or whole. Term is going to be after death. Whole is going to be both. So you definitely want to, if you can, place the trust as the owner, and then the trust as the beneficiary. If you have an agent that you work with for your life insurance, that's going to help you as well. It's going to make things a lot easier, less time consuming. You just got to provide them with the instructions and the certificate of trust. Again, if you don't have that, you know, I can definitely maybe lead you in the right direction as to how to find those forms. Because again, a lot of times it's the same life insurance policies that I see pretty regularly. Now, if you do have to complete any of these forms on your own, I just want to give you a couple little pointers that I've kind of taken note of down here. When you're doing an ownership change, like on a non-qualified plan, for example, or a life insurance, there's going to be a couple of sections. It's usually on the third or to the last page of the actual form itself, where it says current owner and then new owner. So keep in mind that you are in the process of changing the ownership. So right now that form is you're the current owner. So you're gonna sign under current owner, just your own signature, or if it's joint, however it is. Those are gonna be the current owners. So you don't have to do any title after that, it's just your name. If it's a new owner, okay, so let's say we're changing it to the name of the trust, then you're going to have to sign after your name, the name that you're the trustee of a certain trust and the date. So for example, this is just an example. Mark Smith is the trustee of the Smith Family Trust dated 2/3/23. And that is exactly how you will sign it. You will sign your name with the comma and then the trustee of that trust name and then the date. I know it seems like a lot, but I've had it where if you don't do that, they send the forms back and you have to redo it. So they're very picky about that. If you don't sign them exactly the way they want it, when it comes to the new ownership part, they send the forms back. And again, I've had them come back because we just had the client sign his or her name and then trustee after it. That seems to not be good enough. They still want the full name of the trust after it. Just to let you know, to save you some grief on that. Beneficiary changes. So if you're changing the beneficiary on an asset, you don't have to worry about all that title stuff. All you have to do is sign your name to that document. Because we're not changing ownership, we're only changing the beneficiary. So you're the current owner, so you're just going to sign your name, if that helps at all. It's really just with title changes that we have to worry about all this verbiage. Property. We're going to do the deeds. We're going to do all the footwork on this. We're going to file it. We're going to get you the copy after it's filed. The only thing you need to remember is if, you have another property that you want in the name of the trust. If it's in Pennsylvania, there's an additional fee for that. Again, I think it's $250. And if you have to have a deed filed in another state because you own property in another state, that's fine. We're happy to do it. We're just going to have to hire another attorney in that state to complete that filing, and they will send the cost to us and we will forward that on to you, the grantors. Last, homeowners insurance. Very important. If you place any of your residents or your properties in the name of the trust, on the homeowners policy that you have for that particular property, you do need to put the trustees' names under the section that is called additional insured. Now, the policy itself can stay in the individual name because, it is your home, but the trustees have to be named somewhere on that policy. Typically, it's under a section called additional insured. So when you call your homeowner's insurance company to do that process, you can tell them that you just need, and in the case of it's you and your wife, for example, as the trustees, or just you as a trustee, you would just let them know that under the additional insured section, I need the trustee who is this person named, okay? And again, you can leave the name of the actual insurance under the individual or individuals' names, okay? Now, lastly, just to let you know, I'm going to be here for you for 30, 60, 90 days. I'm going to check in with you probably through email or a phone call just to see how you're doing. If you're coming across any roadblocks or stumbling blocks that you need help with, that you need my advice on, I'm going to be here to assist you with that, to let you know what has to be done or how you can get around that, or, we'll try to come up with ways to get that done for you. Now, after 90 days, if you really can't fund these assets, you're just having all kinds of issues, or you just don't have time, or you just don't want to deal with it, it's just too much paperwork, I can assist you with that process. There is an additional fee. It's $1,500. I'm happy to do it. Again, there is a fee for it. However, please keep in mind that I cannot fund the trust alone due to privacy laws. So I can't just go in and make changes to all your assets. The companies and the financial institutions don't allow me to do that because I'm not named as an owner on that products. So I can't just do it for you, but I can help by completing the forms, talking to your financial advisors if they have any issues or questions, helping to get that done, following up with them, or meeting with you in the office to sign into a website to help you get the online completion done if you're having trouble with that. Those are the things that I usually can help with, and maybe take some of that burden off you if you're really struggling with that. However, we do really want to try to have you do it yourself to save yourself some money. And it's usually not too bad. Again, if you have a financial advisor or an agent that you work with, honestly, they're very familiar with all this and they can usually get it done pretty quickly. And it's just not a lot of strain on you. So we advise you that if you have those individuals, to definitely use them. And I will get you the instructions and the copy of the certificate of trust that you can forward on to those particular individuals so that they can complete this process for you. Okay. So again, just reiterating that I am still here for you for any questions, concerns that you have during that 90 days. We value your business. And obviously here at Bloemwood Associates, we thank you for choosing us and making the decision to start your estate planning. It's a great thing to do, and you're going to be glad you did it. But yeah, we're here for you, and anything that I can do to assist you, I'm going to try to do. Okay. Thank you for taking all the time you have with me today. And if you need to rewatch this video and look at my notes that I'm going to provide to you, I would constantly do that because it is hard to remember all this stuff. There's a lot to go over. I do it every day, so it's easy, but there is a lot of stuff that you have to try to remember, and feel free to access this video whenever you need to. Again, thank you and have a great day.